Hello there, and welcome to the premiere podcast of Morning Latte with the Beeklers. I'm Cynthia Beekler.
And I'm Bill Beekler.
We have the pleasure today to talk to you about House Bill 3928, which deals with dyslexia. And we have found the results are in and that dyslexia is in fact special education's baby. And so we're going to go through the process and give you some highlights of this in this podcast.
Yeah. So everybody grab your coffee. Mine is just regular coffee with almond milk.
Mine is hot tea, because I don't drink coffee. But hey, it still looks good.
So, all right, so let's jump into it here. I've got House Bill 3928, Texas House Bill 3928 in front of me that deals with these changes in dyslexia. So let's jump into it. And let's start with the history of dyslexia. And Cynthia, maybe you can explain a little bit how this legislation came about. Because obviously legislation isn't created in a vacuum. There's a build up to it and there's a reason that it comes about. So let's talk initially about some of the history of dyslexia in Texas and how it works.
And Bill's correct. We have had this a long time coming. As you all know, in Texas, and this is specifically to deal with the Texas legislature and the changes that occurred, we were unique in Texas, as we are in many things, and we had a different setup for dyslexia than most states. Initially, dyslexia could be provided under general ed and or 504. Eventually it moved to be under 504. And then there was an expose that was done by the Houston Chronicle several years ago that dealt with the fact under special ed, we had a cap as to how many students could be into special education. And that was through TEA, it was 8.5%. And they did the series that talked about students not getting services. So the U.S. Department of Education became very curious on that and came down and did an investigation and interviewed about 12 schools of different sizes and talked to a variety of those who were working for the school as well as parents. And they found that many kids were not getting referred because this was a compliance issue for schools and that they would be cited if they did exceed those numbers. And so in that bundle, they also looked at dyslexia, because as you realize, dyslexia is subsumed under a specific learning disability. And they looked at what are we doing for dyslexia? And they're finding that a lot of kids weren't being referred for dyslexia until second or third grade. Well, as you all know, we learn to read in K through 2, and then we actually read to learn in grade 3. So we were putting these kids further behind when they weren't getting assessed and getting the services they need while they were learning to read. And as a result, there was legislation that occurred, but we also had many changes that happened along the way. The Fed still allowed us to have 504 dyslexia, but we were supposed to be referring, and always should have been referring, if a kid needs more than that the dyslexia instruction that was occurring at 504. So time evolved, TEA kept getting cited, and they were not relieved from corrective action. And that was slowly chiseled away. And eventually we had in another time frame, they changed it where the special education testing had to occur for dyslexia, and that was the main funnel. And they allowed, though, they said if a parent refused to have special education testing, then it could occur under 504. But we couldn't encourage them to go for 504. And it said it may be specialized instruction, and with conditions applied. And so we still had a dual system going, but it was slowly, you could see, being weaned away from 504 because the testing had to go through special ed. Well, with all this hammering that kept going on, remember TA was still not being relieved from the corrective action. So we are here and we found that the legislature met. And so again, now we have some legislations that has dramatically changed how we have addressed, or what statute addresses special dyslexia.
Okay. So in the special education process, we got to do evaluation, we need to do testing. And you're talking about how we're moving away from dyslexia 504. Does a parent have a choice when they say, I want my child tested under special education, or I want my child tested under 504? What does the legislation say about
Well, the legislation now has taken away any choice. So if a parent wants their child tested for dyslexia, it will only occur in special education. There is no option of them being evaluated under 504.
Okay, so in the past, we deal with this, and sometimes a parent does not want their child tested under special ed or being in special ed. So at this point, if the parent refuses the special education evaluation, can the parent say, no, I want that for dyslexia?
Not anymore, not anymore. When they want dyslexia evaluation or services, special education is going to deal with it. So they've taken away the dual system completely, in the sense that now special education, as we said, it's kind of, this divorce is going on, it's finally getting finalized. And while 504 may have some residual custody rights, they're about to be terminated completely. It is now special ed's responsibility. And so a parent doesn't have the ability to say, I want this, but I don't want that anymore. They don't want special ed. They aren't going to get any special education dyslexia testing under any other venue within the school. All dyslexia testing will be done by special ed.
Okay, so special ed has to do the testing for dyslexia. What about some of these issues that come up on the referral process? So the school obviously can do that. Can a parent refer their child for an initial testing under special ed for dyslexia?
Parents can always refer their children for testing, and certainly they can refer their child for special education testing for dyslexia. We as schools have the option to look at, is this a valid reason to evaluate? Do we suspect that the student has a disability that's needed specialized instruction and related services? And so when we're looking at that, we have 15 school days. Once a parent has requested that an evaluation be done in writing, we have 15 school days to say, yes, we're going to evaluate. And if we say, yes, we're going to evaluate, then we're going to give them notice of evaluation. We're going to give them the written consent form to fill out. And we're going to give them procedural safeguards. Or we can say no. And if we say no, then we give them our notice of refusal, which is your prior written notice saying, you've requested it, we're not going to provide it, and the reasons why, plus procedural safeguards. If we're going to say we're not going to do it, then of course, it's kind of harsh on the prior written notice when we say reasons for refusal. So we say we recognize, you have these concerns, we aren't seeing any issues at this point, but we will monitor them and monitor under your multi-tiered, system. MTSS can do it, your RTI, and you can say, we'll continue to monitor them. And sometimes it may be valid. If the kid's never been exposed to any instruction, you don't see that there's any issue, then we don't have any basis for making a determination or suspecting that. So you can say under prior written notice, no, you don't, we're not going to test them, but we're going to monitor them. I think most parents just want to make sure you're aware and that you have their kids back.
Okay, very good. So when we test for special education, obviously federal law provides there are certain categories that we test for. There's not a specific category called dyslexia, I would imagine. So which eligibility category would this dyslexia testing under special ed fall under?
Yeah, it's under specific learning disability. We don't have a separate section called dyslexia. Dyslexia and all its corresponding disabilities that would go with that, like this, dysgraphia and the rest, are subsumed under specific learning disability. Specifically, if we're testing for dyslexia, we're looking at the categories of basic reading skills and reading fluency. So those are areas that we will be testing under specific learning disabilities to see if they have dyslexia. If they do have dyslexia, what we'll end up saying is that they meet the specific learning disability criteria, and you'll say the areas with the condition of dyslexia.
Okay, so we get to that point, meets the eligibility criteria. So does that mean that student is automatically placed in special education?
Remember, no student is automatically placed in special education based on evaluation. The evaluation determines, and it's by a multidisciplinary team, they determine whether or not a student has a disability. But there's two prongs to whether or not you qualify for special education. First is having a disability. The second is to also have a need, an educational need for specialized instruction related services. So we're looking at a two-pronged test. The first prong is done by the evaluation, which says you has a disability. Ultimately, is the R that says due to your disability that you need this specialized instruction. Okay, so the R determines that you qualify for it. You can't qualify though unless you have a disability. So again, we have a two-pronged process. The evaluation is one that determines disability. The R determines whether or not they qualify based upon that disability.
Okay, so the educational need still comes into play as it does in every other circumstance. So he said the art committee is the one that makes the determination ultimately. Is the standard protocol dyslexia instruction considered specially designed instruction? Because of course, special ed, you have to have specially designed instruction. So is the protocol dyslexia instruction, is that considered specially designed instruction?
And this is where they made it undeniably clear. It is considered dyslexia, the standard protocol for dyslexia instruction is now specialized instruction. And that's why now, anytime a student needs dyslexia instruction, then they are going to qualify for special ed. Because the only place you're going to get dyslexia instruction is under special ed. 504 cannot provide this dyslexia instruction moving forward, except for a limited circumstance, and we'll talk about that.
Okay, so 504 is not the avenue, so let's look at staffing now. Okay, so it's a special education issue. Child qualifies, R determines that the child fits into special education because there's an educational need. Is it required by this new law that the student be taught by a special education teacher?
No. Now, oddly enough, this is normally when it is specialized instruction, it's going to be a certified special education teacher involved. But I think when they married these two systems, they are recognizing we have a lot of teachers who provide dyslexia instruction who have been under general ed. And so what they are allowing is those that are providing this instruction don't have to be a certified special education teacher. They just have to be trained on the dyslexia program and on what dyslexia is. So that is what they are, I would assume, looks like a working out of a bill on the existing system that we had and where they're trying to make it be.
Okay, very good. So, okay, let's look at some of the issues that may arise with this too. I mean, it's easy if everybody's getting along and everybody's going in the right direction on this. But of course, we have situations where a parent says, I don't want my child in special education. I don't want my child in section 504. The child has a need for dyslexia services. Can we provide those dyslexia services outside of the special education context?
Well, here's the interesting part on the statute, which is kind of contrary to what we've done with every other disability. The reality is this. Now it says, if you don't want special ed and your child needs dyslexia instruction, then, and you're not agreeing to be in special ed, they're not going to get dyslexia instruction. But I do want to make it clear though, we as a school still have the obligation to address this child's needs. And so while we may not be giving them dyslexia instruction, we can always address a child and provide interventions under RTI, because RTI does not require parental consent and RTI does not require disability, which is the beauty about RTI, is that we're there to help any student who is at risk or has needs. And so be aware that a lot of the strategies that are done within the dyslexia programs are also just good, scientifically research-based strategies for any reading instruction. Because there are some students who don't have those issues necessarily about phonemic awareness and the rest, but they do need interventions for reading. And so just because a parent is not allowing us to provide it under the venue of special ed, it does not mean that I'm not going to address a student's needs, maybe not with a specific dyslexia program, but I'm going to do reading interventions for that student under RTI, because we're never going to let a child languish because of the fact that a parent may at this point not understand the whole process. Our most important requirement, our most important mission is to make sure we meet every kid where they are. wherever they have strengths and weaknesses. And we don't worry about labels, whether or not they get the services. So we may not be providing them their dyslexia program, but there are certainly tons of other reading interventions that we can do with the students that would address some of, maybe all of the same type of issues.
Okay. All right, let's talk about some logistical challenges. You know, as I'm listening to this and looking at the bill here, we're in the school year, there's a lot of kids receiving dyslexia services under 504. We're gonna have to transition over on that. So what do we do from the assessment standpoint? So do all these kids now that are receiving services under 504, do we have to test under special ed in the future? How are we gonna deal with this logistically?
We got a window. I think what the legislature is basically allowing is if the kids are in your dyslexia program under 504, and they are hitting those benchmarks and those targets that the dyslexia program you're using has in place, then they can stay in it. But remember, this dyslexia programming is normally considered a short-term intervention. So it's only 12 to 18 months that a student may be in it. So maybe longer, but the bottom line is it's still pretty finite. And so what they've done is basically given us a time frame to allow students to basically work their way out of dyslexia programs under 504. I call it basically attrition. They're doing attrition here. And so we have until the end of 2024, 2025 to provide services under 504. If students don't need those services after 2024, 25 school year, they got to be assessed under special education, and they have got to get the services under there. So from that perspective, know that we are going to have this year, and then you got next year. No later than my belief than December of 2024, you got to see what students are looking like they still need to have the dyslexia program. So we'll have sufficient time for us to assess them under special education so that we can provide them the services under special education during the 2025-2026 school year. We also remember for any student, this has always been the case, if we have a kid right now on 504 that we suspect needs more than what they are getting under 504 in the dyslexia instruction, the program's not working for them in the same vein as it is everyone else, that's somebody you should refer now. We don't wait until December of 2024 if we see that a student is struggling even with the interventions in 504 with the dyslexia instruction. So those are the areas that we look at when we're doing it. But remember, 504, all your visitation rights will be over as of 2024, 2025. You will not be playing with dyslexia anymore. It is all going to be special ed in the 2025-2026 school year. So this divorce is complete. The child will be in the full custody of special ed in the 2020-25, 2026 school year, and 504, you have no visitation. You don't even get to write a letter.
Yeah, interesting. So it seems like it's a long time off, but it's not.
No.
When you start looking at 25 to 26, it seems like we've got a lot of time. But as you all know, time moves pretty swiftly. So these changes are in effect. They gave us a little bit of breathing room, but 25, 26 is going to
come. And please know, and we definitely want to encourage you to definitely come to our conference, the Nelly conference in the fall. We have a December 7th, 6th, 7th, and 8th.
Right.
But one of the topics is going to be the evaluation, and there are some changes in the dyslexia law regarding the dyslexia evaluation, specifically who is going to be involved with it and addressing that problematic issue. So we are fortunate to have the renowned Dr. Gail Sherry going to provide us great insight on how to do the dyslexia evaluation with the new requirements that this statute puts in place on how to make sure we're complying with that and doing what we need to do for programmatic purposes as well when dealing with students with dyslexia, as well as several other topics in this conference that is coming up. There are several things, including marijuana, that was discretionary versus vape, which became mandatory, how to address with that, the threat assessment, dealing with the aspects of the MDR, in addition to several other questions that we're having to deal with in this one. It's a great conference, which we always love and it's always well attended. And we strongly encourage you to come and discuss that. There's also other aspects of the dyslexia law that I'll be talking about, which includes what kind of notice we have to give regarding students who go to the DAP on dyslexia testing. So
you can find out anything you want about the conference on nellylaw.net. You jump to that and that'll take you to the conference registration. And it'll go through all the topics and everything that you do. Now, this is going to be, some of it is going to be live, but it is webinar this year, this December. So you'll have access to this and your folks will have access to this as we move forward. So as Cynthia said, there's a lot of interesting topics that we're going to discuss. And we're looking forward to that. But we've got a lot of water that needs to go under the bridge before that. So we're going to keep coming back and doing our little podcast here of topics that should be of interest to you. One thing we're always going to have to say, and it's true, we're required as lawyers, is that if you have an individual situation, a specific situation that you're dealing with, please seek counsel of your attorney, your school attorney, to deal with any specific issues. It's kind of an overview of the statute, but I think we hit on some of the major points here. Again, a lot of change, so we look forward to moving forward with this.
And thank you so much for joining us for our premiere podcast.
Yes, I hope you had a cup of coffee with you. Enjoy your morning, enjoy the rest of the day, and enjoy your week. And we look forward to talking to you soon.
And we'll see you at the next podcast with Morning Latte with the Big Cheers.